Good morning, everyone. Today, let us discuss the concept of vested interest and contingent interest. The Transfer of Property Act deals with two kinds of interest. One is vested interest, other one is contingent interest. Section 19 deals with vested interest and section 21 deals with contingent interest. Now, let us go on to understand what is vested interest. Where on a transfer of property, an interest therein is created in favor of a person without specifying the time when it is to take effect, or in terms specifying that it is to take effect forthwith or on the happening of an event which must happen, such interest is vested unless a contrary intention appears from the terms of the transfer. Now, vested interest is said to be an interest which is not subject to any condition precedent. That is, it is not depending upon happening or not happening of an event. A person takes vested interest in property when he acquires a property right in it, but the right of enjoyment is deferred till a future event happens which is certain to happen. Thus, for example, if a Hindu widow adopts a son, but there is an agreement postponing the son's estate during the lifetime of the widow, the interest created in favor of an adopted son is a vested interest. It does not depend upon the condition precedent. Example, the performance of an act. It is to take effect on the happening of an event which is certain. That means the adopted son has present proprietary right in the estate, the right of the possession and enjoyment being deferred. That means it is being postponed. So, let us see the essential characteristic features of a vested interest. The following are the three main characteristics of vested interest. First one, a vested interest does not depend upon the fulfillment of a condition. That is, it creates a present and immediate right. Though the enjoyment may be postponed to a future date, it may therefore be vested in possession or vested and not in possession. The second characteristic is a vested interest is not defeated by the death of the transferee before obtaining the possession. It will pass on to his legal heirs. And third essential characteristic is a vested interest is transferable as well as heritable interest. Now, after knowing the three characteristics, let us see the another concept attached to the same concept of vested interest is right vested in interest and in possession. There are two stages of vested interest. It may be an interest vested in possession, as where a transfer is made in general terms without specifying the time when it is to take effect, or is expressed to take effect forthwith, or it may be an interest vested and yet not in possession, which means that there is a present indefeasible right to future possession or enjoyment as and when the enjoyment is postponed by some prior interest created by the same transfer. That means a person gets a right in the property immediately, even though the possession may be postponed due to various reasons, but the person gets a right immediately. It means right vested in interest. Now, an interest is said to be vested in possession when it gives the present right to immediate possession of a property, as when the property is transferred to A without specifying the time when it is to take effect, then the transfer is said to be vested in possession or enjoyment. In a vested interest, the interest is complete, but on the happening of a specified event, it is divested. The true criterion is the certainty or uncertainty of the event on the happening of which the gift is to take effect. So the interest is already vested, and In case in on future event which is to take place, which must happen, then we say interest is vested. For example, under section 22, under section 20, where a transfer of property, an interest therein is created for the benefit of an unborn person. He acquires upon his birth a vested interest, although he may not be entitled to the enjoyment thereof immediately on his birth. In case the person is not born alive, then the interest which is already vested will be divested and it will go back to the transferor. So the property may be, the rights may be vested as on date of transfer when the child comes into existence, but the criteria is that the child must complete the minority period to get a vested interest. Before the criterion period, if the ultimate beneficiary is no more, then the property gets divested, the rights gets divested, and it will immediately gets transferred to the transferor. Now there is an exception to the vested interest. This exception we can see in section 21, where under a transfer of property, a person becomes entitled to an interest upon attaining a particular age, and the transferor also gives to him absolutely the income to arise from such interest before he reaches that age, or directs the income to be applied for his benefit. Such interest is not contingent, but it is vested interest. It means to say is that if the property is to be transferred on a future date, but the income of that property is already given to the ultimate beneficiary, then such rights are not contingent interest, but it is called as vested interest. And section 22 goes on to speak about transfer to members of a class who attain a particular age, where on a transfer of property, an interest therein is created in favor of only those members of a class who attains a particular age, which such interest does not vest in any member of the class who has not attained that particular age. So here we are talking about where the property is transferred to a class of persons, where the transferor says that the ultimate beneficiaries who attain the age of 18 years shall get the property immediately on attaining the majority. So until and unless the ultimate beneficiary completes the minority period, it is only a contingent interest, it is not a vested interest.